In a shocking twist that has set Nigeria's political corridors buzzing, Nnamdi Kanu, the detained leader of the indigenous people of Biafra, has dropped a political bombshell, listing former Attorney-General Abubakar Malami, FCT Minister Nyesom Wike, and several top political heavyweights as witnesses in his terrorism trial. From retired generals like Theophilus Danjuma and Tukur Buratai to sitting governors Sanwo-Olu of Lagos and Hope Uzodinma of Imo State, Kanu's witness list reads like a roll call to Nigeria's power elites. As if that was not surprising enough, Kanu's case took a different turn this morning, October 23rd, 2025, as his lead counsel, Kanu Agabi, applied to withdraw from representing the detained IPOB leader, stating that the defendant had taken the case back from them. All the senior advocates of Nigeria on the defense team also withdrew from the suit, a development Nnamdi Kanu himself confirmed in court. So Nnamdi Kanu told the court that he would be representing himself for now, though that might change later. When the judge asked if he should be assigned a lawyer, he declined the offer. So, defending himself orally, Kanu argued that the court lacks jurisdiction to try him in the first place. So the matter is getting even more interesting. But let's go back to the motion. The motion was filed before the Federal High Court in Abuja, and this motion seeks to subpoena 23 witnesses divided into two categories that he calls ordinary but material witnesses and vital and compellable witnesses, which I will explain in the course of this video. The people that he also categorized, I'm going to explain in the course of this video. So he is invoking Section 232 of the Evidence Act, which gives him the right to compel even top government officials to testify under oath. What are the key points of the motion? Number one is that he is intending to call 23 witnesses in total, and he's proposing dividing them into two categories. I had said we have the ordinary but material witnesses and the vital and compellable witnesses, all to be summoned under Section 232 of the Evidence Act of 2011. He is also asking the court for a 90-day time frame to conclude his defense, given the number and status of the witnesses he intends to call. Now, he further states that he does not have a problem personally testifying on his own behalf, providing a sworn account of the facts, denying the allegations, and explaining the political context of his statements and actions. Now, who has he called? Who are the people he has named? Among the high-profile individuals listed as part of the vital and compellable category are Abubakar Malami, former Attorney-General of the Federation under President Muhammadu Buhari, and the person that initiated this particular case in the first place. Nyesom Wike, Minister of the FCT and former Governor of Rivers State, Theophilus Danjuma, former Minister of Defense, Tukur Buratai, former Chief of Army Staff, Babajide Sanwo-Olu, the Governor of Lagos State, Dave Umahi, Minister of Works, Okezie Ikpeazu, who is the immediate past Governor of Abia State, and then Ahmed Rufai Abubakar, former DG National Intelligence Agency. Also added to the list is Yusuf Bichi, who is the former Director General DSS. The motion says that these individuals are viewed as vital and compellable, which is the court may issue subpoena or summons under Section 232 of the Evidence Act to ensure their attendance. This development comes just days after a medical panel, as ordered by the court, declared Kanu fit to stand trial, paving the way for his defense to begin on October 24th, 2025. It also follows months of delay, a dismissed no-case submission, and a string of protests across the country, the most recent led by activist Omoyele Sowore in Abuja. That protest led to the arrest and remand of Kanu's lawyer, Barrister Aloy Ejimako, his brother, and 11 others. The tension is palpable, with court orders, police crackdowns, and public outrage shaping the drama. It is also important to note that the 22nd of October 2025, Kanu was brought to court by officials of the Department of State Services (DSS) to meet with his lawyers inside Court 7 at the Federal High Court headquarters in Abuja, the same courtroom where his terrorism trial is being conducted. Now, the meeting held between 9 a.m. and 12 noon, and it followed a directive by Justice James Omotosho, who had earlier approved the session as part of the defense team's preparations for trial. Now, Justice Omotosho, in a ruling delivered on October 16th, granted Kanu 6 consecutive days, beginning from Thursday, 23rd of October, to open and close his defense under an accelerated hearing arrangement. Now, for a lot of people, the court is ready to get this case over and done with. But with this latest development, does it look like Kanu's legal team want him out anytime soon? And like I said in my previous video, the argument that some people pose is, if Kanu's legal team, if his supporters can be on the streets chanting that he is innocent, then it means it should be easy for them to prove that to the judge in court. Now, a date has been set for his defense to be opened, and the judge has said he should have meetings with his legal team in order to afford them the time to prepare for his trial. Remember that months ago, his lawyers complained that the DSS never allowed them the privacy to engage with their clients, and so they have not prepared for this matter as much as they should. But the little time that they also had to prepare for the matter, a lot of people said they were in the streets rather protesting, which, is considered sub judice. But let's go back to the story. So the shocker this morning, 23rd of October 2025, Kanu says he's not in need of his lawyers anymore. He is ready to defend himself. Even when the judge offered to give him a lawyer, he declined. So it is definitely going to be interesting. Maybe his lawyers can, become full activists, and while Kanu is in court defending himself, they will be in the street chanting that he should be released. By calling those who once stood at the heart of government machinery, Kanu appears to be turning his defense into a mirror reflecting Nigeria's power dynamics, asking uncomfortable questions in open court. So if the court grants his request, these powerful figures from Malami to Wike and Buratai could be subpoenaed and forced to appear in court to testify. Imagine the spectacle: serving ministers, ex-generals and state governors taking the witness stand in a trial that has already polarized the nation. But if the court refuses, then Kanu's team could argue that he has been denied a fair trial, a move that might escalate his case from a legal battle to a political firestorm. So from all indications, this matter is far from being over. The request for a 90-day window and a large number of witnesses could be viewed by prosecution and opponents as a tactic to delay. On the other hand, he might legitimately believe the number and nature of witnesses justify the time. So it's a question of whether the court will grant the subpoena. Listing the names is one thing. Getting the courts to issue summons, especially to current office holders, is another. Their attendance or refusal may itself become a contested matter. Now, the defense will need to show how each witness is material and relevant to rebut the charges against Kanu. The courts may access objections from the prosecution regarding relevance, this being a terrorism and treason related trial. Well, if the court grants 90 days, proceedings will have to be managed carefully, especially given the number of witnesses. If not, Kanu may have to proceed on a tighter schedule. And given the high-profile nature of the witnesses, the case may attract heightened media attention, political commentary, and potentially influence public perception of the judiciary and security institutions. Kanu's motion also references what he perceives as prior unfair treatment, example, extraordinary rendition and detention. And so while he is now moving into defense, those prior issues could continue to influence the backdrop and appeals. For example, in his motion, he says justice must be manifestly seen to have been done. So we'll see if the court will grant Kanu's request, but we are anticipating to see how the prosecution will react to the listing of witnesses and the request. Will they challenge certain witnesses' relevance or the timeline? And if the court issues a summons, will the named officials attend and testify? If not, will that lead to further motions or objections? Once the defense opens, how will Kanu present his case? What will his sworn testimony say? And it is important to note that the trial of Kanu and the involvement of senior officials may have implications for perceptions of Nigeria's handling of separatist movements, state security responses, and the judiciary's independence. But in all, are we really going to see the end of this case, or is this a never-ending legal drama, legal battle? Are we really going to see the end of this case? For somebody like me, I cannot wait. Something tells me that Kanu's legal team is not really all that interested in, putting up a defense, because for a lot of people, what is the relevance of the likes of Nyesom Wike to this case? What is the relevance of, Governor Sanwo-Olu to this matter? What is the relevance of Tuko Buratai to this matter? What is the relevance of Okezie Ikpeazu to this matter? Like I said, this is also a political and illegal strategy that he has just adopted. Let us see how he's going to maneuver this, and let us see how the prosecution will accept or process this entire development. And here on Political Arena, I will ensure that I keep you updated. Do well to like, subscribe, share, and be a part of the conversation in the comments. See you on the next one.